Welcome, ladies and gentlemen, to the World Justice Project's 5th Global Forum. This afternoon we have the rare privilege of having a keynote conversation between two remarkable people. Dean Elizabeth Magill of the Stanford Law School is an extraordinary scholar and teacher of the law, and was recruited by Stanford University to come to its law school to occupy an endowed chair and to lead its faculty and students and staff as its dean in 2013. She has recently accepted a unanimous request that she serve another full term as the dean at Stanford Law School. Justice Ruth Bader Ginsburg was also a distinguished scholar and teacher of the law, and as you all must know, a pioneering advocate for women's rights, changing in a material way the jurisprudence of the United States in that subject area. In 1980, she was appointed by President Jimmy Carter to the U.S. Court of Appeals for the District of Columbia Circuit, where she served with distinction. And in 1993, she was appointed by President Bill Clinton to the Supreme Court of the United States, where she has earned a leadership role. Dean Magill and Justice Ginsburg know each other well from the time when the dean was the law clerk to the justice. So this is a bit of a reunion, if you will, not their first reunion by any means. So please enjoy this keystone conversation. We will hear from a legal education luminary and a judicial legend. Please give a warm welcome to Liz Magill and Ruth Bader Ginsburg.
Thank you.
Well, thank you, Bill, and thank all of you for being here. And let me join Bill in saying, Justice, it's a privilege to have you here and to see you again. And I know who the luminary is on this stage, and it is you. So it's a pleasure to be with you. So I just had a series of questions, just an informal conversation that I hope will get you talking, which I'm sure it will. So. The first question is, you've throughout your career, especially on the bench, made a career of going abroad in the summers and also before the bench, teaching abroad. It's been an important part of your career. So one question I have is, how has teaching in countries outside of the United States affected you and your views on issues? And more specifically, maybe what are some of the most interesting things you've learned from foreign students, faculties, or judges?
Liz, first, may I say how glad I am to be here. This is the third forum that I have attended. I think this forum gives one hope for the world. And then Liz Magill, she was the kind of law clerk I wish I could have kept forever. And she is one of the most outstanding law deans in the United States, as you just heard. She accepted a second term to be dean of the Stanford Law School, which is probably, even more than your first institution, even more than Yale, the number one choice of law school applicants. So, teaching abroad. It started right here in the Netherlands. When I was on the Columbia Law School faculty, Columbia had a program with Amsterdam and Leiden, and they would meet 1 year in Amsterdam, the next year in Leiden. It was not for US law students. It was originally students they were young lawyers in the 30 to 35 age range. And the first years, it was Western Europe, and then expanded to include Eastern Europe, and then the world. my next teaching experience was at the Salzburg Seminar in Austria. And there too, it was a program, an introduction to U.S. law for lawyers from all over the world, lawyers maybe 5 or 6 years into their legal career. And then after that, since I got the good job I now hold, I have been teaching in summer programs run by U.S. law schools, and I wrote down, there have been so many, I've lived a long time. But let's see, there was Istanbul, Paris, Rome, Sorrento, Crete, Barcelona, Venice, Vienna, Siena. I left out a few, but those have been wonderful summers for me. Some of the programs, most of the programs were for U.S. law students. The one in Venice included both students from the University of Padua and U.S. law students. And that formula was wonderful because I think the students learned more from each other about their systems than they did from the lecturers. I think the understanding that's developed among people through that kind of experience, a summer learning experience together, is invaluable. My first exposure to another legal system was when I was quite young, after I finished my clerkship for Federal District Court. I was engaged by the Columbia Law School Project on International Procedure to write together with a Swedish co-author a book about the Swedish judicial system. Sweden was chosen because it was a country that had a new code of procedure. Well, it's not new now, but it went into effect in 1948, and by the time I got there in 1962, it had been enforced long enough for one to examine it. What they tried to do, it was basically a Germanic system, but they tried to infuse what they thought was the best of the common law way. So they introduced on the civil side one concentrated trial episode, not the kind of episodic procedure that they had earlier. And they introduced questioning, examination of witnesses by the lawyers instead of by the judge. So that was a great experience for me to see how another system went about trying to achieve the same ends of a fair and just legal system, but went about it in some different ways.
So the World Justice Project has gathered 400 people in The Hague this week who are committed to advancing rule of law all around the world. Looking at the trends in the world right now, are you optimistic about the future, pessimistic about the future? And if optimistic, what makes you optimistic? And if pessimistic, what makes you pessimistic? Maybe end on optimism.
I had to start with optimism because how could you be otherwise? I can quote, it was something that the Reverend Martin Luther King said many times. I don't know where it originated, but he said, "The arc of the moral universe is long, but it bends toward justice." And that's what I believe about the world. I mean, I've lived long enough to see some remarkable changes. I grew up during the Second World War, and to see the end of that horror as remarkable to see the end of apartheid, and not only in South Africa, but in our own country. Well, you're so young, Liz, that you may have heard about it, but you didn't experience it. In World War II, we were fighting a war against racism, odious racism, and yet our own troops were segregated by race. I think World War II was the beginning of the end of apartheid in America. So, what was the rest of your question?
I think we're marking you down as an optimist.
Oh,
So
yes,
don't-
yes.
You don't have
definitely.
no reason for
Yeah.
pessimism,
Well,
or
well,
you're not
you-
pessimistic.
Because I've seen changes like that.
Right.
Changes that some people thought would never happen.
Well, let's talk about one of those changes. You've been a very strong advocate about the need to place more women on the bench everywhere in the world, in the United States. And so why do you think that's so important? And what can countries do to increase the number of women on the bench?
Well, let me tell you how there came to be women in numbers on the bench in the United States. When I graduated from law school in 1959, there was only one woman who had ever been on a federal appellate bench. Not the U.S. Supreme Court, but the U.S. Court of Appeals for the Sixth Circuit, Florence Allen. She was appointed by Franklin Delano Roosevelt. She retired the year I graduated from law school, and then there were none. Until President Johnson appointed Shirley Hufstetler from the Ninth Circuit. President Carter made Shirley Hufstetler the first ever Secretary of Education in the United States. And then there were none again. It wasn't any lawyer or judge. It was President Jimmy Carter looked around at the U.S. judiciary and said, all those folk look just like me, meaning they're all white men. And then he said, but I am President of the United States, and the United States is so much richer for the diversity of its population. So I am going to appoint members of minority groups and women in numbers to the federal courts. He had only 4 years in office, no vacancy on the Supreme Court to fill, but he appointed over 25 women to federal trial courts, district courts, and 11 to courts of appeals, and I was one of the lucky 11. By beginning that trend, he did something grand. There was never any compromise on quality on the whole. I think the American Bar Association rated the Carter appointees to the judiciary very high. And at the end of his term, in October of 1980, he had a reception for all the women he had appointed to the bench. And he said, although he had no Supreme Court appointment to make, he hoped history would remember him for changing the complexion of the U.S. judiciary. The next president, Ronald Reagan, didn't want to be outdone, so he was determined to put the first woman on the U.S. Supreme Court. And that was, he made a wonderful choice in Justice Sandra Day O'Connor. And now there are 3 of us. The hardest time for me on the U.S. Supreme Court was when I was all alone, when Justice Sandra Day O'Connor retired. Mm-hmm. It didn't look right to have one little woman and 8 rather well-fed men. The public perception was wrong. But now we are 3, we're 1/3 of the bench. We're not doing as well as our neighbor to the north. Canada has 4 women, and one of them is their Chief Justice. But we're doing a lot better than was the history. People sometimes ask me, well, when do you think there'll be enough? When will there be enough women on the court? And my answer was, when there are 9. People are astonished. Well, for most of our history, we have had 9 men, and nobody thought that there was anything strange about that. But it is exhilarating for me to see the enormous change, even in law school. So I was one of 9 women in a class of over 500, and today most law schools have as many women as men. I was never taught by a woman. There were no women on law faculties, and now we have Dean Magill, and I think you have some sister deans.
Yes.
So
there was a 1-month period when the deans of Harvard, Stanford, and Yale were all women before Martha stepped down. So, yes, but a lot.
For all those years, the judiciary, the legal profession, was missing half the talent. So I'm happy to see, I'm more than happy, exhilarated to see the changes that have occurred in the legal profession.
Another change, it seems to me, and others, is the kind of the dialogue between courts of the highest jurisdiction across countries, and the borrowing and the learning that happens. You mentioned the Canadian court, and I know you know many judges from other countries. Do you think that dialogue is a good thing? And it seems sometimes controversial. Do you think it's here to stay?
I think it's very important for U.S. judges to experience other systems. The Supreme Court has several exchanges. So the first one I went on was in India with Justice Scalia. I've been to the European Court of Justice 4 times. We have every second year an exchange with the Supreme Court of Canada, with the now Supreme Court of the UK, it used to be the Law Lords. We've had a few exchanges with French jurists. The jurists from abroad are visiting the Supreme Court constantly. And it's something that we encourage. I was still on the Court of Appeals when they had the first International Appellate Judges Conference in Washington, D.C.
And why is that a good thing?
Well,
that exchange.
We can learn from each other. We can lose some of the myths that we believed that turned out not to be so. Not that our own system will change, but at least we will appreciate why others do what they do. One big topic when we meet with jurists from abroad is dissenting opinions. In as many systems, there is a single judgment for the court. Dissents are not recognized. And I recall vividly a visit from some French jurists, when I was on the Court of Appeals, they listened to the argument in a criminal appeal, and I said I would send them the judgment when it came down. Well, it came down 2-1, and this French judge at first was horrified. He said, how could you, in a criminal case, somebody is going to prison, and what is the law if one person disagrees? And then he thought about it, and he said, yes, I criticize your system because the law is supposed to be clear and certain and stable, and the people shouldn't have the impression, a different impression. But then he said, I really envy you. You must feel so secure in your legal system that you're ready to be transparent, that you're ready to say, yes, there are tough legal problems that may not have a clear and certain answer.
That leads into the next question, which is many observers have detected a decline in faith in institutions in general, in worldwide, including courts. And I'm wondering if you have thoughts about what are the keys to building trust and confidence in courts?
The esprit of the judiciary, I think I can say for the United States that of the three branches of government, if you had a public opinion poll, the federal courts would come out way ahead of the first branch. It wasn't always that way. When I think back to 1993, when I was confirmed, there were only 3 negative votes, although I had spent 10 years of my life litigating cases under the auspices of the American Civil Liberties Union. When Justice Scalia, who, when he was nominated in the 1980s, the vote was unanimous. It hasn't been that way for the most recent appointees to the court. Not for my current chief, not for Justice Alito, Justice Sotomayor, Justice Kagan, and most recently, Justice Gorsuch. My hope is that we will get back to the way it was not so long ago and the way it should be. But I think it will take people in our Congress with the kind of determination that Jimmy Carter had. He saw something that he thought was wrong, and he promoted change. There will be people in our Congress one fine day who will say, we're not serving our country well by the kind of division that now exists. And I'm an optimist, so I expect to live to see that day.
In 2016, you published the book My Own Words, which was a collection of your writings from over the course of your career, and you've been such a prolific writer and speaker. Can you talk a little bit about what you choose to write about and why you choose to write, and what's the process like of deciding what to put in this book, for instance, of all the things you've done?
Well, My Own Words was supposed to follow a biography of me. My official biographers are Wendy Williams and Mary Hartnett. They started writing about me in 2004. And when it got into more recent years, the idea was that the biography would come out and then we would have a selection of my writings, speeches, and articles. But as the book preparation it began to exceed a decade, I said, why don't we flip the order and let's have My Own Words come out first. But Wendy and Mary did the selection, and they wrote an introduction to each section. I wrote the overall introduction to the book, but this is every part of the book begins with something that Mary and Wendy wrote. And they started with my 8th grade editorial in my public school newspaper, the Highway Herald. And I wrote then about great documents that have been important in advancing human rights in the world. So I started with the Magna Carta, and I ended with the UN Charter. Because in those days we were very hopeful for what the UN might become.
Mm-hmm.
So the book starts with that, and then there's a letter to the editor that I wrote as a college student at Cornell. It was a bad time for our country. There was a huge Red Scare. Senator Joseph McCarthy saw a communist in every corner. And the paper, the student paper at Cornell, had written about why wiretapping was a necessity because of the needs of national security. And I wrote a letter saying that wiretapping is not the good idea that the article had said it was, that our freedom to think, speak, and write are so precious, but also vulnerable, that people become so overwhelmed by the need for security that they're willing to sacrifice the most basic values of our nation. So, and then the book goes on to the decade when I was a flaming feminist. It was a hard job for Wendy and Mary because I don't know how many speeches I gave about the Equal Rights Amendment. They were all variations on the same theme. My dear husband once said, Ruth has the brief, and all the other briefs were variations on that theme, and I had the speech and the article. But nowadays, if I write, I try to explain our system, how the court works, the value of dissenting opinions, jurists who have inspired me.
No more flaming feminism in your writing now?
Yeah. Well, at my age, I wouldn't call it flaming.
Well, you won all of those cases, so it's not flaming anymore, I guess, right, as an advocate. I guess, but the next topic I wanted to ask you about was judicial independence. And before we leave this topic, you've held so many, done so many incredible things in law. As you reflect back on it, what was the most memorable of the jobs you've had? Is it this current job, or was it being an advocate or a professor?
The job I now have, I think, is the best and the hardest I've ever had. Well, you know that I do. My law clerks work very hard, but I work as hard, I
Yes,
would
you
say.
do. I remember having lunch with the Chief Justice when I clerked for you, Justice, and that the justices had tea or lunch, and it was Chief Justice Rehnquist, and he initiated a conversation about the best job in law. He was the sitting Chief Justice of the United States, so we all thought that was a pretty good job. And he insisted that his best job in law was being head of the Office of Legal Counsel, because it was a team and you were an advocate and you had a client. And it was more fun, he said, than being Chief Justice.
Well, I've never been at the Office of Legal Counsel. It is a very good job. Justice Scalia was also head of the Office of Legal Counsel. But I don't know, don't you agree with me that being on the Supreme Court is...
I think so, yes. Yes.
Well,
Good work if you can get it, right, Justice?
You know,
Yes.
so many lawyers, jurists from abroad, they say, don't you think there should be a term limit? As many constitutional courts abroad will have a 9, 12, 15-year non-renewable. That's the way to protect judicial independence. It's non-renewable. So we don't worry about how the people, you do what you think is according to the law and what is just. I have tremendous job security. The Founding Fathers were wise enough to put two protections in Article 3, and one is we hold our offices during good behavior, and the other is our salary, it cannot be diminished while we hold office. So if the Congress doesn't like what the court is doing, can't cut our salary. But I contrast lifetime appointment with the system that most of our states still have. That is, at some level, judges are elected, not appointed, and often those are contested elections. So when I go abroad, that's a question I'm often asked. How can you say that you take great pride in the judicial independence that exists in the United States when judges run for office? And I have no good answer to that question. I do know that since Justice O'Connor retired, that is one of the projects that she is most engaged with. It is the attempt to convince states to have appointed rather than elected judges.
More power to her. That's a great goal. Very hard to change. It's so deep in the U.S. system.
Yes, you can see, and it's hard to take away from them. People have a right to vote for their judges.
Right.
And you're going to tell them it's no longer your right. The governor will do the appointments or a bipartisan commission. But we have seen, even in the state where you now live,
Yes.
where California has a system, it's not a contested election, but periodically the justices stand for an up or down vote. And the Chief Justice, Rose Bird, was brought down, and two of her colleagues.
Yes. Because of decisions they'd rendered.
Yes.
In cases.
Yeah.
Right.
Yeah.
Death penalty cases. Yes.
Yeah.
It's not a pretty picture. So that's a good segue to judicial independence more generally. This group here, of course, is working to advance the rule of law in many different countries. And I had a question about what can judicial personnel or judges or supporters of legal systems in the world do to shore up rule of law and keep them free of undue political or economic interference?
Well, I might give the example of Singapore. Their approach to judicial independence is to pay their Supreme Court justices $1 million a year. That's certainly not true in the United States. I think our law clerks are making more money than we are just a couple of years out of law school. It takes an esprit. After all, it's existed now more than 2 centuries in the United States, since the great Chief Justice John Marshall. The judges weren't so secure in the beginning, It may be apocryphal, but Andrew Jackson was alleged to have said, well, that's what Chief Justice Marshall said, now let him enforce it, because the court has no armed forces at its control. It has no purse strings, but yet I think the system has existed for so long, I'll give a few examples. One case that I disagree with, Bush v. Gore. So who was going to be president of the United States? My own view was that it's not a question for the court to decide. But the court did take the case, made its decision. It was a divided decision. But the next day, there were no riots in the streets. Everybody accepted that Bush would be the president. I think the most dramatic example was not a Supreme Court decision, but it was a trial court. Judge Sirica in the District of Columbia, he was trying burglars. What did they burgle? They burgled the Democratic National Committee headquarters. And he was conducting the trials and said, every person must give relevant evidence. The President of the United States has relevant evidence. It is the tapes of the conversation he had in the Oval Office. President Nixon turned over the tapes, and the next day he resigned from office. I mean, that's a real authority.
Yes. It's a hard question how you build that if you don't have it right now, I guess.
Yeah.
That's the topic for this group.
It takes time and persistence.
One of the objectives of the World Justice Project is to build coalitions between the legal sector and the non-legal sector to promote rule of law. And I'm wondering if in your career, interactions with non-legal professionals have shaped your view, or in ways you've seen have contributed to the advance of the rule of law, or experiences outside the legal sector affected your view.
Well, I think if a country wants to have a thriving economy, it's got to have the rule of law. I mean, you have to be able to make contracts that will be enforced. So I think those two go hand in hand, a thriving economy and the rule of law. So I am hopeful that the rule of law will become increasingly the way systems operate. Now, it's very hard in some places where judges are not paid enough to support their families. So we will have inevitably corruption when that's the case.
So I know that other than the law, another great love of yours is opera. And do you think there's a connection between law and opera, or are those just two independent parts of your brain and heart?
I will be in Santa Fe in August, and I will, with the young artists, do a program on law and justice in opera. And even better than that, there is an opera titled Scalia Ginsburg. It will have its second production this summer in Cooperstown, New York at the Glimmerglass Festival. And I'll just give you an idea of how it goes. It starts out with explaining the difference in approach to legal text of Justice Scalia and Justice Ginsburg. So it starts out with Scalia's rage aria, very Handelian in style. And he sings, "The justices are blind. How can they possibly spout this? The Constitution says absolutely nothing about this." And then I answer him, I say, you're searching for bright line solutions to problems that don't have easy answers. But the great thing about our Constitution is that, like our society, it can evolve. This opera, by the way, was written by a young man named Derek Wang. He is a composer, a librettist. He majored in music at Harvard, and he has a master's degree from Yale. And then he decided that for his profession, it would be good to know a little bit about the law. So he enrolled in the University of Maryland Law School, and he took a constitutional law class. He's reading these opinions, dueling opinions, Scalia Ginsburg, and decides that could make a very funny opera. The plot is roughly based on the magic flute. So Justice Scalia is locked in a dark room. He is being punished for excessive dissenting. And then I enter through a glass ceiling to help him go through the trials that he has to pass to get out of the dark room. Then a character left over from Don Giovanni, but this one is the commentatore, said, "Why would you want to help him? He's your enemy." And I explained, "He's not my enemy. He's my friend." And then we sing a duet that goes, "We are different, we are one." And it's different in the way we approach a legal text, but one in our reverence for the Constitution and for the institution we serve. So I'm very much looking forward to the production. The entire libretto is available in the Columbia Journal of Law and Arts.
Well, last question, Justice. This is the first day of a 4-day conference, and everyone here is going to be working hard over the next 4 days to think about strategies to promote rule of law in the countries that they're going to return to. Do you have any advice for the participants as they do their work this week and then think about returning home to do their work?
I can just say from having experience with this forum is it's a wonderful opportunity. You will have many presentations for the entire group, but you're going to meet separately. I think there are many group sessions and the ideas that you will exchange. I think meeting each other, all of you have been outstanding in promoting the rule of law in your own countries. I think you will gain strength from knowing that there are others, people like you, in other systems that are striving to promote the rule of law.
Justice, I wanted to say one last thing, which is there's a at the beginning of Democracy and Distrust, John Hart Ely's work on constitutional interpretation, he says about Chief Justice Warren that you don't need to choose many heroes if you choose the right ones, and that's how I feel about my experience with you, Justice. Highlight of my life today.
Thank you.